Welcome to another episode of Talking Legal with Templars. My name is Olufemi Oyewole. I'm the Senior Advocate of Nigeria. I'm a partner in the Dispute Resolution and Arbitration Practice Group at Templars. Today is an interesting episode of Talking Legal because I have three of my brother Silks here with me. It's the first time we're doing this at Templars. Welcome, Leonard Silks. Just beside me, I have Adewale Atake, Senior Advocate of Nigeria. Wale heads our Dispute Resolution and Arbitration Practice Group. Next to him is Godwin Omoaka, Senior Advocate of Nigeria. Godwin sits in our Dispute Resolution and Arbitration Practice Group. And finally, I have Inam Wilson, Senior Advocate of Nigeria. Inam heads our Labour and Employment Practice Group. He also heads our Aviation and Maritime Practice Group. Thank you, Leonard Silks. Today, we'll be discussing various interesting areas of law, starting from stabilisation and the arbitrability of tax disputes. We'll also discuss issues arising from investor-state disputes, as well as the new world of work, and finally, insolvency. I'll start with my brother Silk Wale. Well, there's been a controversy surrounding the issue of arbitrability of tax disputes. Can you talk us through this, given your experience in this area?
Now, in my view, I think there ought not to be any controversy when one makes the proper distinction between a purely tax dispute and a contractual dispute which impacts tax legislations. Now, a purely tax dispute will arise from an assessment, demand notice, decision, or action of the Nigerian Revenue Service.
It's a tax authority.
Yes, which is tax authority. Such disputes fall squarely within the jurisdiction of a tax appeal tribunal and are not arbitrable. However, contractual disputes which impact tax legislations are arbitrable disputes and fall within the jurisdiction of an arbitral tribunal. So when one puts the issue within these two boxes, then one finds that really there ought not to be any controversy.
No, broadly, I agree with Wale. I just think the point is that the argument is more unreal than real. And the distinction, if any, between tax arbitrability, right, and contractual dispute is really very tenuous.
Thank you for that. And leading on your experience, I know you've been involved in a number of significant investor-state arbitrations over the years. Can you talk us through some of the experience on this, and what have you found in investor-state arbitration?
Well, we've been involved in a number of investor-state arbitration, FTAs system, all right? Nigeria has not been sued as much as other African countries, I think, and Egypt has the highest number of ISDS cases with about 46. But we've been involved, and in the few instances where Nigeria has been sued, it's really basically relating to the extractive industries, oil and gas, and we've had to advise our clients on some of those matters, although some of them were settled. I know that we are also working right now on one of the ISDS matters. So it's investor-state arbitration is something that is really topical, right? You have the exit system, whereby these matters are adjudicated under the exit framework. But the point is, for you to be able to get to the exit system, you must be able to activate the jurisdiction of the tribunal. And the way you do that is by consent. The parties must have offered their consent either in a BIT, an MIT, multilateral investment treaty, or FTA, what we call an FTA, free trade agreement. You can also do that via domestic legislation for the national laws, all right? And there are, again, what we call investment contracts. So this is essentially what you find in investor-state arbitration. And the claims relate to foreign investors who have come into a country, put their funds in terms of investment in that country, and perhaps there has been a breach of the obligation to protect them. And so therefore, they sue the whole state in an investment claim. And so you have the investor on one side versus the host state on the other side. And it relates most often than not to the breach of a bilateral investment treaty, because that connotes an international obligation. That doesn't necessarily mean that the claims cannot arise under, for instance, an investment treaty or a domestic national investment law. It can, but I mean, they are rare, they're not very common. So that is the legal basis for bringing investor claims.
I mean, I have a couple of questions and then I'll come back to that, but I just want to touch briefly on Inam's experience. I keep hearing about this world of work I'm not sure what it means. And Benedict, I know you've done a number of things in that space. Can you talk us through it?
Thank you very much. We call it the new world of work. And this you'll find that both at the local level and internationally. So new world of work from a local perspective or cross-border perspective. This basically refers to the changes, the evolution, if I can use that expression, in the world of work. So traditionally, we were used to working within a certain geographical location, an office with a maybe structured workspace, structured work in terms of your job description and all of that. But in recent times, all of this has changed. And now we have work. Sometimes you don't even know that you are in a workspace, that you are working, because of the evolution that has come out. And what that has done is that it has changed the nature of the employment relationship dramatically different from what we were accustomed to knowing. I know the traditional nature of employment relationship is between a master and a servant, or if you are in the public service, the government and the employee. But all of this has changed dramatically. So sometimes you have your gig economy, people who are in the gig economy, for instance, there's a debate whether there is an employment relationship between them and the gig economy. So you take your Amazon, for instance, it's an online platform. And then people go there and do all manner of stuff. They get paid for it. You take your Uber driver, your Bolt driver, and all of that. You take your delivery guy, the guys that do your delivery. Do they work for you, the app owner, or do they work for themselves? And so they get paid through the app. So does that create an employment relationship? So that changes so many things. Then, of course, because of the technology that we have and smartphones, internet, people work from off their phones. People today, the Gen Z don't need an office to work. They come together through maybe WhatsApp or a phone app, and they set up structure and they start to work. That has changed the form and nature of employment relationship. Then most importantly, labor jurisprudence, the laws and regulations that govern the workspace. It has changed dramatically to respond to the changes in the nature of work and in the forms of work. And I'm sure that as we discuss further, we'll get to explore this. So one important point to make is that work, employment, labor is integrated into business. Businesses are created based on work. So whether it's a multinational company, it's a local company, whether it's a company in the extractive industry, in the finance sector, in the transportation sector where I also operate, you need workers. And so these changes impact workers in this place. And so employers, we represent employers, essentially. We always need to let our clients know, who are employers, that the world of work is changing and there is need for them to get abreast with these changes. Thank you.
If I may just add to what Inam has said, it's amazing how the transformation since COVID of the concept of the workplace has happened since COVID, all right? It's so fast. And the question now is, what is the workplace? Yes. It's a very fluid concept. And I think what Inam and his team has done very well over time is to be able to try to, sieve the wheat from the chaff so that people can understand that, especially for employers that we present more often than not, can understand the dynamics and the key differences, between the old conceptual traditional definition of a workplace and the new one, which is represented by the Gen Zs, as Inam says.
It's a good thing you mentioned COVID, because if you recall, COVID impacted a lot of businesses negatively. So first, what happened was businesses had to change the way they worked, the way they operated. But very importantly, a lot of businesses face insolvency situation because demand for their product reduced, especially for those of us in the transportation industry. So you imagine shipment of goods were totally affected. This created insolvency situations. Femi, I know you are in the insolvency space. Maybe you'll be able to relate to this as from an international best practices perspective.
Thank you for that, Inam. I think that Nigeria is doing well in that space, but not quite the ideal place. We've moved from a liquidation-centric country to a rehabilitation country. What I mean is, in the past, creditors were not concerned about the survival of any company they were trying to recover debt from. But now, with the passage of the CAMA 2020 and the Insolvency Regulation 2022, we're seeing more emphasis on the survival of the business itself while trying to recover your debt, rather than the previous approach. We're not quite there yet because we don't have a uniform framework like most countries do. We also is undeveloped and is fragmented, but we're starting to see increased attention being paid to this aspect to ensure that, for cross-border insolvency cases, Nigeria is starting to improve its ranking. So yes, we're not quite there yet, but we can see some improvement.
Like Godwin said, the whole idea is not to kill the business. But when you bring an insolvency proceedings, it is sometimes used as a pressure point to be able to recover your debt. So it's more used as a strategic
tool for
debt recovery.
Thank you for that, Wale.
For me, just to put in, insolvency affects employees.
Yes.
The potential disruption, it's unimaginable. In my experience, we've had situations where employees have gone to the court, the National Industrial Court, to try to get restraining orders, stopping an insolvency or stopping their employment from being terminated. How do you deal with this? Do you think that the laws as they are now are sufficient, or ex parte orders are being abused in Nigeria?
Yes, I would say the position of the law is a bit flux on this issue because first things first, ex parte orders, people have argued about the constitutionality of ex parte orders because essentially you are restraining someone without actually hearing from the person. So we're in the past, I would say our courts, they used to be granted as a matter of routine, but there's now an increased awareness on the part of judges, even on practitioners, that you do not grant this sort of injunctions or ex parte orders routinely. There's a very high threshold before you grant an ex parte order. And the reason for this is because it has the effect of disrupting a business. What we are starting to see is that in the past, before you get an ex parte order, you would have to give an undertaking as to damages. You would sometimes see applicants going to court to just say, I undertake to pay damage, without actually showing the court that, for example, a business of this magnitude, you have the capacity to actually pay the damages that the business may suffer as a result of these injunctions. So we're seeing more and more that our courts are starting to pay attention to these undertakings, right? The other point to make is that when applicants go to court, I understand the need for you to get an ex parte order to preserve your rest, which is essentially what an ex parte order is supposed to be. But I think our courts should be a little bit cautious. When you see a solvent business, someone is paying salaries regularly, for example, an oil and gas company that has an oil and gas asset that is immovable, it's not the best thing to do to just freeze all the assets when they're clearly not going anywhere. That's the first one. Secondly, you can see a claim of $1 million, for example, and someone says, oh, I know this person has a bank account. The bank account has $45 million. You freeze the entire bank account. What we are starting to see is our courts are starting to ring fence. They can ask you to say, no, we're only going to freeze $1 million rather than freezing the entire sum there. So we don't disrupt the business. You don't kill the business, right? You don't affect people's operations because you're trying to recover your money. So what we are trying to advise our clients at Templars is that, look, if there's an ex parte order against you, first, that ex parte order is only supposed to last till you are ahead. It's not supposed to last till the proceedings are done. You have the right to go to court and present your case for the court as to and look at the order, see why it should not last the entirety of the case. Secondly, we're also trying to tell our clients that, look, if you've actually been affected by an ex parte order, you can write down your damages, plead them specifically. This is what you couldn't pay your employees. You had obligations that you could not fulfill because this order was wrongly obtained against you. You can file an action and actually recover those losses that you've suffered as a result of those ex parte orders. Wale and God, I don't know if you have anything to add.
I think the point I'm trying to make is the draconian use of ex parte orders, especially where third-party interests are affected, such as employees. So because this could have adverse effect on employees and families of the employees. So I think our courts should be very, very cautious in granting ex parte orders, especially in insolvency proceedings. That is not to say that in deserving cases it should not be granted. It should. But I think it should be done as a last resort.
We're talking about stabilization initially. I've read the phrase stabilization used. I know you've acted on a number of big arbitrations. But now I want to drive the point on in relation to Nigerian law now. I know there's a new tax act, right? And there's a petroleum industry act. What does stabilization mean in relation to these specific laws?
Let me start by explaining the policy reasons behind stabilization before addressing your question. Now, any investor, before making any investment, want to know the applicable laws affecting its investment, because an adverse change in that law could have a serious impact on his investment. And so what the investor tries to do is to seek assurances and promises from the government that during the lifetime or lifespan of his investment, the law will either not change or where the law changes, then the contract should be renegotiated in such a way such that the investor is made whole or put in the position it will have been before the change. That's, in very simple terms, is what is the policy behind stabilization. It gives stability to the investment being made. And so, before the coming of the Petroleum Industry Act in 2021, and now the Tax Act of 2025, which mirrors Section 305 of the Petroleum Industry Act. Stabilization prior to these two legislations was governed by the parties' contracts. So one could only make a successful or a stabilization claim if there is a contractual provision to that effect in your contract. Now, with the coming into effect of these two laws, the Petroleum Industry Act and the Nigerian Tax Act of 2025, it has somehow fettered the right of an investor to make a claim for stabilization by imposing certain limitations. Now, where some of these limitations are where, for example, stabilization will not apply to a generally applicable taxes, such as income tax, your VAT, and your withholding tax. it will also not apply where, for example, taxes and levies are made to give effect to modern principles of environmental law, labor law, health and safety.
Okay.
Or where, for example, taxes are made to give effect to Nigerians' commitments on climate change under the United Framework Convention. In all of these instances, you may not be able to claim for stabilization if you are affected by these limitations. And so, by the combined effects of both legislations, what we are likely to see from both the courts and arbitral tribunal is a very restrictive approach to the interpretation of stabilization provisions. However, for contracts entered into before the coming into effect of the Petroleum Industry Act of 2021, those contracts, the stabilization provisions in those contracts will continue to apply, and the restrictions imposed by Section 305 will not apply to such contracts. So if you had a broad stabilization clause in those contracts, one should be able to still make a very, very successful claim for stabilization.
Just to go that's for Godwin, right? Would you say these sort of clauses, do they encourage investors to come into a country?
Stabilization clauses do, because the whole idea is to stabilize the foreign investor, right? Keep him in the position he would have been, but for the change in regulation or legislation. Wale made two very important points. He talked about the legislation. He talked about protection regulations. The whole idea with stabilization and why foreign investors seek stabilization is because whenever there is a new law, don't forget, the state has the right to regulate in the public interest. And so when there's a new law, there's already tension between that new law and the obligations and the benefits that have been conferred either in a contract or in a statute to an investor. So the investor seeks stabilization to protect that, and they can bring claims under two framework. First, under a contract, if they have a contract, an investment contract, a domestic commercial contract, or they can elevate it using an umbrella clause in a bilateral investment treaty to make it an investment treaty claim.
That takes me to my next question that I was going to ask you, right? Is there a difference between investor-state arbitration and domestic arbitration?
Of course, there is a big difference between investor-state arbitration and domestic commercial arbitration, right? So with investor-state arbitration, you have two parties, the investor and the state. And it implicates public law, right? Because we are talking about the breach of obligations under a BIT, a bilateral investment treaty, an MIT, multilateral investment treaty, or a FTA, a free trade agreement, or right. So that is essentially the dispute, the host country and an investor. But with commercial arbitration, it involves two private entities who have a dispute over their contract, right? And the jurisdiction of the tribunal, right, derives from the arbitration clause in the agreement, and it essentially relates to a dispute over private rights, failure to pay, failure to perform obligations under a contract, and all of that. So that is essentially the difference between investor-state arbitration and commercial arbitration.
So, you spoke about certain treaties, right, that can give rise to an investor-state arbitration, right? Do we have any such, I know Nigeria is a signatory to some of these treaties, but do we have anything in Africa that we're currently looking at?
Nigeria is signatory to so many treaties, right? So we have the first generation bilateral investment treaties to which Nigeria is a signatory. And then we now have the more modern second generation BITs, and then the Nigeria-Morocco BIT, for instance, will fall into that category. That's the 2016 BIT. But also on the continent at a larger level, Nigeria has signed the AfCFTA, the African Continental Free Trade Agreement. And the whole idea with the African Continental Free Trade Agreement is to make Africa a common market, right, for goods, right, and to boost intra-African trade, business, creation of jobs by removing both tariffs and non-tariff barriers that militate against trade within the African continent. And then in 2023, February of 2023, the investment protocol, right, was adopted of the FTAs, and what that protocol do is to strict to promote and facilitate and safeguard intra-African investment. So essentially, before the adoption of the African protocol, Africa has intra-African BITs. We have over 170 of them, about 173 of them. But with the adoption of the investment protocol, over a 5-year period, you will see that once the protocol becomes effective, you see that the African states are supposed to phase out their first generation BITs within a period of 5 years. So it's very, very important. And if you're looking at the dispute resolution mechanism under the investment protocol of the AFTA, the AFTA investment protocol itself, provides that will be in an annex to the protocol. So that annex is currently being negotiated. So until the negotiation of the annex is completed, we will not get a clear sense of where we're headed.
Our dispute will be resolved.
At the moment, I do know that the protocol provides for, in relation to investor-state dispute, a multi-tiered system. Begins by consultation, negotiations, mediation, and then arbitration. But then the difference is that the arbitration will have to be at the state-to-state
level. It's not an investor that can trigger that.
Yeah, it's not an investor level. And if you have an investor want to bring a claim, then you have to bring it under the auspices of your state.
Okay. So before I go back to Inam, I wanted us to talk about this issue of stabilization again, right? Are there specific changes to the Nigerian Tax Act that may potentially trigger stabilization? And the reason why I ask is that as soon as the Tax Act was passed into law, Nigerians, even businesses, have been worried about the effects it may have on their business. There's been a lot of controversy, and I know you've done many things like this in the past when there's a change in law. So I'm asking now specifically for the Tax Act, are there specific changes to the Nigerian Tax Act that may potentially trigger such claims?
I think one of such provisions in the Nigerian Tax Act that readily comes to mind, and which has been of great concern to the IOCs, I think, is Section 86 of the Nigerian Tax Act, which provides for decommissioning and abandonment. Prior to the Tax Act, the PIA created a decommissioning and abandonment fund. And under that regime, monies paid into that fund for decommissioning and abandonment were treated as tax-deductible expense. Now, what the Tax Act has done, I believe in Section 86, is to make funds paid into the D&A account not tax deductible, except 30% of the D&A funds have been domiciled in a bank or in an account in Nigeria. And so, for that reason, it has raised serious concerns to some of the IOCs because it could have an adverse impact to their bottom line. And so many of them are seeking advice on this issue to first of all determine, one, the level of impact it could have, and whether it could potentially result in them triggering the stabilization provisions in their contracts. And my view is that yes, it could, if they could demonstrate, one, that one is a change in law, and that it has material adverse effect on their bottom line, and that the limitations, again, imposed by Section 305 of the PIA and 88 of the Nigerian Tax Act do not apply.
Thank you for that, Wale. Speaking about bottom line, I was going to ask Inam, this new world of work, what are the risks that employers could face? Because if they don't move ahead with the times, it could potentially affect their bottom line. So I want to know the risk and how they can address these issues.
Enormous risk. So let's start from the contract itself. We were the era where you thought that your contract of employment was sacrosanct. You know, we in law, we talk about sanctity of contract. The new world of work, especially the new labor jurisprudence, has changed this dramatically, because before, the employment contract, it was the bedrock of the employment relationship. Now it is no longer the bedrock of the employment relationship. So you find a situation where you have tendered your employment contract and you say, this is what the employment contract provides. But the National Industrial Court will say, well, we cannot accept the provision of your employment contract, because by virtue of the third alteration to the Constitution, which came into effect in 2010, we are allowed to apply international best practices. Also, we are allowed by the third alteration to strike down any provision of a contract that the court considers to be servile and to constitute unfair labor practice. And so you find your situation as an employer that your contract is no longer respected. The second risk is what we call reclassification risk. So, and this plays in the gig economy especially. So you have set up your business structure in a way that you have a lot of independent contractors working for you. And so this is tax efficient. And then, of course, you have outsourced a lot of your operations to reduce your costs as a business. So as far as the structure that you have set up is concerned, let's say there's a labor provider, or there's a middleman who provides the labor for you, or there is the independent contractor who works for himself. As far as you are concerned, they bear their tax obligations, for instance. They bear their pension obligations. They bear their gratuity entitlements. They bear everything that an employee would want to get. But the National Industrial Court says, no, we have to look at this relationship again. And we've had situations, for instance, in the UK, the popular Uber case, where Uber drivers were classified as workers when the structure that was set up by Uber then was meant for them to be independent contractors. Now, so decisions of that nature are creeping into Nigeria gradually, where you find that independent contractor is reclassified by the court as an employee. And now what we find in the cases where we have had this occur is that because there's no contract of employment between the employer and that employee, the entitlements of the employee are not specified. The court now takes it upon itself to give awards which are not based on any negotiated entitlement. So that's a big risk. One of the risks that I need to emphasize relates to policy of government. Wale and Godwin talked about stabilisation, right? And they mentioned the Petroleum Industry Act, PIA. Now, one of the things that have come out of that is the National Industrial Court has held that the PIA is an expression of government policy on different aspects of life relating to the petroleum industry. One of those is labor and employment. And you know there are extensive provisions in the PIA relating to labor and employment. Now, you find that the decision of the court, which, by the way, is now a matter of appeal at the Court of Appeal, was to the fact that when you construe the PIA alongside the guidelines for the removal of Nigerian employees in the oil and gas industry, that it is mandatory to obtain the consent and approval of the then DPRO, now NUPROC, before an operator in the oil and gas sector can release a Nigerian employee. That guideline takes its roots and ancestry from an earlier guideline that was passed by the DPR. And that earlier guideline had been struck down by the High Court, the Court of Appeal, and the Supreme Court because it goes against the very nature of employment relationships. It goes against, first, there's no privity of contract between the DPRO and the employee. DPRO is a regulator of the operator, but has no relationship with the employee. So, secondly, the court said DPRO cannot impose a term into the employment contract that was not there when the employment relationship was formed. So this has been a headache for a lot of employers in the oil and gas sector because they are faced with the devil and the deep blue sea situation where must they hold on to potential termination of an employee to await the approval of the DPRO. The approval is not routine. The approval doesn't come in a few days. The DPRO itself becomes a clog to the employment relationship because if you, as an employer, you approach the DPRO for permit, that application may be in the DPRO for months. And the employee that you've concluded that you want to terminate continues to remain in the business, eating fat salary, taking fat salary. So that is one of the risks in the new world of work.
Thank you. You made a very interesting and a very important point, a valid one at that, about divisions of the NIC. But even the fact that the NIC is a court of first instance, an important comfort for employers because their divisions, as much as they try to reflect international best practices, are contrary to the Court of Appeal and Supreme Court divisions that embody and clearly defines the scope, right, of what employment should be, such that even right now, as the National Industrial Court is trying to evolve and introduce these new concepts, until those higher court divisions, Court of Appeal and Supreme Court divisions are appealed, I think the employer should be in a comfortable place, in addition to the fact that they potentially have a right of appeal against those decisions to the Court of Appeal and further.
That's a very good intervention. Thank you very much, Godwin. As a matter of fact, you're absolutely right. The National Industrial Court is a court of first instance. It's a trial court. And so appeals lie from the court to the Court of Appeal. And at Templars, what we always advise our client is, because of the National Industrial Court being seemingly pro-employees, we always advise our clients that they have a right of appeal, which they can explore, especially when the decision, in our view, really cannot stand the test of the law. And if you remember, there was a case, an interesting case, where the National Industrial Court applied what they call the doctrine of triangular employment, which was not in the contract, and used that to award damages in millions in a class action that was instituted by some employees that were disengaged by their employers, who were service contractors to our client. And so they were granted reliefs that were not based on contract of employment, like I mentioned before. And we challenged this decision. And interestingly, at the end of the day, the Court of Appeal agreed with us and re-emphasized the fact that the employment relationship is what you look to when you're determining the entitlements of an employee. Because take away whether the employment is wrongfully terminated or not wrongfully terminated. Even if it is wrongfully terminated, the court still has to decide what are the entitlements of the employee. That part of the decision has to be based on contractual provisions. The court cannot rewrite the contract of the parties or make new contracts for the parties at the litigation stage. And so even if a decision goes against our client, an employer, we try to appeal.
Thank you, Leonard Six, for your time today. We have discussed issues ranging from the arbitrability of tax disputes to stabilisation. We've also discussed labor and employment vis-a-vis the new world of work. We've discussed issues around insolvency, investor-state disputes, and investor-state arbitration as well. Thank you very much, Leonard Senior Advocate. This has been Talking Legal with Templars, Senior Advocate of Nigeria edition. See you again next time.